But even if Mr. Thompson does seek the death penalty, the case may not be as open and shut as you might think. A defense attorney can always poke holes in a case and try to create doubt. Casey Anthony's lawyer sure did it. It's been 11 years since she was found not guilty of first-degree murder in the death penalty case involving the death of her 2-year-old daughter, Kaylee. And despite overwhelming evidence, Casey Anthony walked free. Joining me now is the judge who presided over that case, Judge Belvin Perry. He's also the former chief judge in Florida's 9th Judicial Circuit. And it is good to see you again, sir. If there were ever a case for the death penalty, Judge, this certainly would take the cake. But do you think that the prosecutors in Idaho are going to seek death in this case?
I certainly think, based upon the Idaho statute, that they will seek the death penalty. Idaho has 11 statutory aggravating factors. In a quick examination of the statute, there are at least 5 aggravating factors that would be applicable in this case that would justify a sentence of death in this particular case. All you need is for the jury to unanimously find one aggravating factor and find that that factor is not outweighed by any mitigating factor. So there's a high probability that death will be the penalty in this particular case.
Okay, but then, Judge, you've got to find the jurors. They have to be death qualified, which means they have to be okay with saying, I could vote for death. They also, on top of that very, very difficult thing to find, they have to be okay with having known so much about this case, but still be able to come into a courtroom and be unbiased about this case. Because frankly, I don't know where you can go in Idaho. If you search a change of venue motion here, I don't know where in Idaho you can go. It's like Casey Anthony. I don't know where in Florida you could go. Everybody knew. It's just hard to find those jurors. And now it's doubly hard if you seek death qualified jurors, right?
You're correct, but the key is not whether or not they have formed any opinions. The key is whether or not they can set aside those opinions and decide the case solely upon the facts in the case versus the law. If they can do that, then they would be qualified to serve as jurors. But it's going to be a very difficult and hard task to find jurors that will meet that particular test.
Yeah, no kidding. It's a double test, right? Death qualified and willing to come in without having formed an opinion. All right. So how often, sir, in all of your years on the bench, with all your experience, how often does it really come to pass that a family decides, like the victims of Chris Watts, those family members said, nope, I want him to spend as long as possible staring at a wall by himself 23 hours a day. I think death is too easy. How many times do families say that?
Very rarely. In my career, I have seen that occurred about maybe 3 times out of maybe 100 cases. But the decision to seek death, even though you take in consideration the wishes of the family, is solely left up to the prosecuting attorney.
But they do take the family's wishes into account strongly, don't they?
They do, but you're going to have to look at the impact. This guy has all the markings of a serial killer. I mean, he went into an apartment complex, went not only to one floor, the second floor, but to the 3rd floor, and he killed 4 people by stabbing. It's going to be kind of hard and difficult as the evidence continues to unfold for this prosecutor not to seek death.
Judge Belvin Perry, I always enjoy our conversations and I always love learning from you. Thank you so much for being on tonight. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.